Sudha madam. Hello. Hello.
Yes, good afternoon, all of you.
Good afternoon, ma'am.
Sudha madam, is it English medium or Telugu medium, madam?
Telugu.
Madam, I am Veera, counselor, madam.
Sorry. English medium, sir. English medium, sir.
అవును సేమ్ వచ్చిందా? అది ఎంతమందికి అడ్వాన్స్ అకౌంటింగ్ కూడా సేమ్ క్లాస్ వచ్చింది. హార్మన్ సార్ తో చెప్పాను, ఈ ఒక్క వారం చూడండి, నెక్స్ట్ మంత్ రేపటి చూద్దామన్నారు. సో దిస్ ఇస్ ఇంగ్లీష్ మీడియం మేడం?
Yes, sir. English medium.
ఓకే మేడం, నేను లీవ్ అవుతున్నా.
Okay, sir. Thank you. Sorry.
యాక్చువల్గా నాకు తెలుగు మీడియం, బట్ ఇది
Okay. English medium, sir.
ఓకే మేడం, నో ప్రాబ్లం.
Good afternoon, all of you. Yeah. Okay, ma. Good afternoon, all of you. Welcome to you all. Previous class we discussed about what is company, what are various types of companies, and incorporation of a company. Under the incorporation of a company, various documents to be submitted by companies at the time of incorporation we discussed. Under that, first Memorandum of Association we discussed. Let us recall about Memorandum of Association, and then in today's class we are going to discuss about the alteration of the detailed information about Memorandum of Association, alteration of Memorandum of Association, the Articles of Association, and alteration of Articles of Association. These are the topics in today's class we are going to discuss. If time permits, we also discuss about the prospectus. Yes, I'm sharing screen, just a minute. Memorandum of Association. That is, a memorandum means it is a primary document which is originally framed with a very due care and concern, because this is a document which represents the company with the outsider world. Represents the company with the outsider world. Okay, so it defines the company's powers and its relationship with the outside world. That's the reason why this document is said to be a fundamental document of the company, and it has to be prepared very carefully. This should be divided into paragraphs, numbered in consecutively, and this document has to be signed by all the members involved in the constitution of this document, along with the signature of the witness. Right? In this document, the management, the organization, or the contributors of preparation who involved in the preparation of this document will discuss about various aspects relating to the company. Those are name clause. That is, under this clause, they mention about name of the company. Under this clause, they mention about name of the company. Okay, and then whether it is a private company or public company, or is it a private company or public company? If then name, what as per the registrar's rules and Companies Act rules and regulations. Name should not be resemble or similar to other existing company names. All these they will take care. And finally, whatever the name of the company they selected, that name of the company along with its logo and tagline or the nature of business will be given under the name clause. The second clause is state, that is situation clause. Under the situation clause, this clause indicates, means under this clause, the subscribers mention about the registered address of the registered office of a company, where it is located, under which jurisdiction it comes, and these details they are supposed to mention. And from the registration of like whatever, whenever they come, whatever the documents they full submit to the registrar for verification, within the 30 days of the incorporation, they're supposed to locate their office under this registered office. Okay, even the registrar will verify the location of office as per the address mentioned in the document. This registered address of it, whatever is there, the registered office address, whatever they specify, upon this address, the future transactions, future dealings, everything takes place. So, like not only that, a company must print, publish its registered office address in every document, official documents that is involved, like its letterheads, bills, papers, checks, whatever it is. The next third one is objective clause. Objective clause tells about the objects of a company or the purpose of the company for which it has been established or incorporated. Generally, objects of a company is classified into three types: primary objectives, secondary objectives, the objectives which are not included in the first two. Okay, generally this enables the subscribers to know, means the objective clause, why do they mention? Because by mentioning the objectives of the firm, it enables the subscribers of the company or the stakeholders who are showing interest to invest in the company to use based on these objects of the company, they will think whether to invest or not, and whether the company is going to give protection to their investments or not, that their decision can be taken. Not only that, even the creditors and the persons dealing with the company can come to know what are the activities, the permitted range of activities of a company with the help of these objects specified in the memorandum clause. Okay. Next, we have liability clause. Under this clause, company mentions about the liability of its members. Generally, the liability of company, the members, for joint stock companies, the liability of members is either limited by shares or limited by guarantee. Okay, so but a company is supposed to specify clearly, are those members of the company liability is limited by shares or limited by guarantee. What does it mean by limited by shares and limited by guarantee? We already discussed this under the features. That is, if it is a limited by shares, the liability of the members is limited to the extent of the share value they get invested in the company. If it is limited by guarantee, the liability of members is limited to the extent of the guarantee that they are given. Okay. In case of when members are called upon to pay the company at any time, these members are liable to the value shares or liability to the extent of the guarantee given. So under this clause, they mention what is the liability of their members. The next one is capital clause. Under this capital clause, company is supposed to give the details relating to the capital of a company. It means what is its total capital, the company's total capital, and upon that, what is the amount of capital company is going to issue and raise, and what are the various types of shares, in how many different types company is going to issue. Okay, and what are the rights of the shareholders, or these shareholders are having. Okay, and what are the rights of the shareholders, not, and then what is the value of share it has. Okay, it is providing the value of share also. So under the capital clause, so what details company give, what is its total capital, and what amount of share capital it is going to issue, and what are the different types of shares it is issuing, what is the value of each share, and then how many shares it is issuing, what are the rights of each types of shareholders. All these details is going to given under this capital clause. Why again? In the beginning only we said the very purpose of Memorandum of Association is to enable its subscribers to know about the company, its powers, and the range of activities to the outsiders. It connects the company with the outsiders. This document connects the company with the outsiders. So this document provides all these in these documents, all these details are provided. Okay, then after this, association clause or subscription clause. What does it mean? Under this clause, okay, all these details in the memorandum or whatever are provided, there's to be how to trust. It is some authentication has to be given, right? Some authentication of the details provided in the document relating to its name, registered office, objects, liability, capital has to be certified or identified. So that will be given by the people who are involved in subscribing for in giving this information. So those all people has to given a written consent that has to sign upon this document. Not only those subscribers of the document, even the what you call a witness. One of the witness also has to sign on this document. Okay, written consent of the directors also must be there. At least 7 subscribers in case of public company, and 2 in case of private company has to give their written consent to buy the shares of the company. And not only that, there also has to sign the put their signatures and name and addresses. Along with these people, subscribers, one witness also will sign. So that's about Memorandum of Association. So it consists of 6 clauses. Under each clause, 5 clauses are mainly relating to the information of a company, which based upon which subscribers will come forward. The next, not only come forward, this tells about the company. The last clause is a clause which says that all the legal formalities required for incorporation of a company has been fulfilled and followed, saying that the subscribers of company are supposed to put their signatures along with their witness. Yes, that's okay. They submit the Memorandum of Association to the company and what do you call to registrar, and they'll get incorporation after certain period of time. Due to certain reasons, a company may need to make changes in its name, or generally name or registered office, or in objects or liability or capital. So any such changes have to be again notified with the registrar. It involves a lot of legal formalities. Alteration of memorandum. Alteration of memorandum means change in the details of memorandum. Change in the details of memorandum. Okay, so change in the details of actually this alteration of memorandum is not that easy. It is very expensive, and it also involves various legal formalities to alter any clause in the memorandum details. Okay, but there are certain situations which make it compulsory for the company to change the details or the information that is given in the memorandum. In such case, what a company can do, what, because each clause requires separate legal requirement. Each clause has separate legal restriction. Each clause requires separate legal formalities to be followed to make alteration. So let us see what is that legal requirement, what are those legal requirements, and how to proceed for alteration. Why, madam? Why can't it's their company? No, it is joint stock company means it's the company which is formed by the members, group of members, public, where public interest is involved, right? So they are supposed to keep a look, take into consideration the interest of the public and say you are there. Okay, so keep your consideration the interest of the public. That is the reason why it is necessary for every company to consider those changes only unless otherwise it is unavoidable. So now let us see the each of clause and its requirement. First one is alteration of name clause. If a company wants to change its name, if a company wants to change its name, just a minute, okay. Wants to change its name, like one name to other name, if wants to change. Okay. Correct. Of a company. Sorry, I'm sorry. If any company wants to change its name due to any reason, say it merged with the other company. Okay. Say Hutch. If you take the Hutch, earlier it is a Hutch mobile net communication systems. They merged with the Vodafone. Okay, now it changed its name from Hutch to Vodafone. Then later on, Vodafone and Idea joined together and changed the name Idea Vodafone. So, like due to mergers or acquisitions, certain sometimes companies may do change their names. Okay, like if you say list, I want a list. Okay, if a companies want to change their names, then recently Facebook changed. What is the new name of the Facebook?
Meta.
Very good. Okay, so Meta, like that, companies may need to due to reasons it may wants to change it. Actually, Facebook is the very popular name, but and gains lot of profits, but it wants to change its name to Meta due to the various reasons. He gave the explanation also why he wants to change the name. So, but it is not that simple. Some CEO announced the name change in the name of the company. But to change that name, before bringing that the change in the name of the company into market, they need to undergo all these legal formalities. Like, what are those? Special resolution. They need to pass a special resolution. Okay, what is special resolution? That we understand under the meetings. Actually, we have a topic called meetings also in our next topic. Not the next topic. Actually, it's our block 4. Meetings of company given under the block 4. Under that, we'll come to know what is special resolution. Okay, if any special important decisions are to be taken, a minimum quorum has to attend. Okay, so in order to take change the name of the company, they need to pass a special resolution and they need to get approval from the central government. They need to get approval from the central government. if it is a change in the name is related, means a private company, a public company is going to get a private company, or a private company is going to get a public company. Then change relates to this. They don't need any simple central government approval is not required. A special resolution is important enough. Say now our public government are like what is that? They converted into private. They're planning to convert public to private institutions. The central government approval not required. If they are like what do you call, a GO is passed is enough. If every special resolution in the parliament is enough. Okay. Name of the company is changed. So, after passing of the special resolution and approval of the central government, the details of a change in the name of the company has to be submitted to the registrar of companies, because again legal identity is required. So you are identified legally as a Facebook. Now you want to change to Meta. Then you are supposed to again, this company, Facebook company, has to give a details about the change of their name and the special resolution acceptance, a copy of acceptance and of the change of name in the special resolution, a copy of central government approval. All these has to be submitted to the registrar of company. Then the registrar will verify and enters the new name of the company in the name of the old in the place of old name, and issue a fresh certificate of incorporation with the new name of the company. If you see what you call Facebook certificate of incorporation of a company, you search in the website relating to the Facebook, you will relating to the Facebook, you will listen just what you call you search, you will get. Now new one, Meta, also you will find. That means earlier when it is registered with the certificate with the Facebook, you are getting it got a certificate of verification incorporation with the name of Facebook. When it changes again with the Meta name, you will find the certificate of incorporation. Okay. Yeah. So when this new name come into existence from the date of fresh certificate issued by the registrar, not the date on which you announced or the CEO announces or decision has been taken. Only after this new name is entered and a new certificate with the new name is issued by the registrar, then only the new name will come into effectiveness. Okay, that's the thing. The next one is alteration of registered office or clause, situation clause. Okay, that means, say, for example, a company has its registered office registered with some address in Bombay. It's located and a given address locating in Bombay. Now it wants to shift in the Bombay only, same Bombay only from one location to other location. Okay, or it may shift from Bombay to Kolkata or Delhi, or it may shift from Bombay to Pune, or it may shift to entirely the state, one state to other state. See, so within the Bombay, same jurisdiction, or within the Bombay, jurisdiction has changed. Okay, within the Maharashtra, Bombay to Pune, okay, or one state to other state. Like that, there may be a chances of changing in the registered office of the business. So depending on the jurisdiction you are changing, the legal requirements involves. Okay, say for example, within the Bombay, Thane place is there. In Thane, only one place to other is Thane to some other what you call area. It wants to change. A simple special resolution is enough in Bombay only. Okay, or if it wants to change from Bombay to Pune, then it needs to pass special resolution and because jurisdiction has changed, Bombay to Pune. So earlier it is under the Bombay jurisdiction, now it is shifted to Pune jurisdiction. So registrar also has to give the confirmation for a change of their address. Okay, and now if you want to change from Bombay to Delhi, means state also changed. In case of such change in the registered office, special resolution as well as confirmation of the central government also required. Okay, so depending on the change of the registered office from one place to other place, they need to go for alteration, and they are supposed to again this also they are supposed to submit the relevant documents. If only special resolution, that document and the new address, with the new address and new jurisdiction details, they're supposed to submit the registrar. If it is a change, the new address, special resolution document, and then special resolution means on that particular meeting, whoever the directors accepted and signatures, all that. Okay, and then the registrar's permission confirmation letter. If it is a state to state, central government confirmation letter, like that, the relevant documents with the new address of the registered office and the jurisdiction under which it comes, these details are submitted with the registrar. Then within the 30 days of the registrar will verify. Generally, that location change and all should take place within the 30 days of the special resolution. Will enter the new address in the book. The next one is alteration of object class. Yes. Alteration of object class means objects based on which subscribers joined the company, trusted the company, and showed interest in joining the company. That objects means because they trusted, and the creditors, if you take the creditors, they trusted, they came to know that the powers and limits within which company is going to act, what is the scope of their activities based on that. So such objectives only company wants to change means it is important again. Generally, it's very difficult for company to change the objectives of the company. So it's a company has no right to alter its objects at all. Okay, but for any reason, if a company wants to change any defined objectives, then they are supposed to undergo various legal restrictions. What are they? First, carry on business more economically. Means the reason for alteration of objectives is for getting more economical benefit or more effective business, or to attain the purpose of a new business or improved business, or to enlarge its local area operations, or to carry on the same business which may conveniently or advantageously combine with the object of specified in the memorandum. Only under these conditions a company can go for alteration. Okay. Generally, alteration is strictly not allowed because based on which subscribers trusted you and came forward, creditors and suppliers, banks lent you money, but now you want to merge with the other company or you want to change your values, will not be permitted. That's the reason why company should prove they want to change its objectives. For any of these reasons, then only it is allowed. By passing a special resolution, they can alter the objects clause, and a copy of such special resolution with the changed objectives has to be submitted to the registrar within the 30 days of the special resolution. Then the registrar will enter these details in the register and again will issue a certified the registration of this alteration within the 30 days of submitting the documents. The next one is alteration of liability clause. Of a company limited by shares or guarantee, again, this also cannot change, because the members join saying that because you promised at the time of when you issued the memorandum, your liability is limited to your shares. And if I want to change and make you liable unlimited or limited guarantee, so the entire company could make collapse, because shareholders all will sell their shares, right? So it is also not cannot be changed. But if any, because to impose the additional liability, members will not accept. Automatically, company will get collapse. So, with the object of imposing the additional liability, if company wants to alter the liability clause, it is not permitted by law. Okay. But if all the members agree in writing or to such change, then it is all allowed. So, for example, limited by guarantee. So, the members who joined limited 30% of guarantee they have given. And with the consent of all members, with the special resolution, okay, we are agreed to take the liability to 40%. Then 10% more we order. Then if all members agree and give their consent, they can change. But generally, not acceptable. The last final one is alteration of capital clause. Alteration of capital clause means capital. Means if a company wants to increase its capital or increase its number of types of shares, issue more types of shares, or divide its more shares, or increase its share value, okay, or to subdivide its shares, or convert its shares into stocks, okay, or whatever the shares are existing and wants to cancel. For any of these reasons, a company can go for alteration of capital clause. But this is only under the special resolution. Okay. So a simple increase of capital or consolidating the shares, converting the shares into stocks. Shares into stock means share means individual. 10 units each share. Say 1 lakh, a company wants to raise 1 lakh capital. 1 lakh capital at a time from one single person, it cannot collect. Companies collect their capital from the public in the form of shares, right? And this means what? 1 lakh capital is divided into small units, 10,000 units. And each unit has given value, 10 rupees. 10 rupees into 10,000 units, yes, 1 lakh. Now, so that the public may come forward to buy the shares of the company, whatever they can able to afford. That's how capital of the company is divided into shares, and each share has given value. Okay, so these are small units. If a company, stock means what? Lump sum, like 100 units, 100 shares becomes one stock. Okay, 100 shares becomes one stock. They're fully paid shares. Okay, if all the 10 rupees are collected from the public, and then company can convert those 100 shares into stock. So these all are not going to affect any interest of the public. That's why with an ordinary resolution, company can do these alterations. But if a company wants to reduce its capital, in case of reduction of capital, company needs to go for special reservation. The next one is Doctrine of Ultraviolets. What is this Doctrine of Ultraviolets? I'll show you. Let me. 1 second.
Hello, ma'am. Which subject is this?
Business law, ma'am. Business law. Under that, we are discussing about Memorandum, Alteration of Memorandum of Association. Just a minute. What is Doctrine of Ultraviolets? Yeah. Generally, company has got its recognition, right, as a artificial person and got its legal identity, right? Got its legal identity also. Right? So, doctrine of ultravirus, ultra means beyond, virus means powers. Means when a company works beyond its powers, then court has a right to cancel its recognition. Okay, company ultravirus means a company that doing its business beyond the legal authority. Doctrine of ultravirus is a company which is doing its beyond its legal authority. A court has a right to cancel its recognition. Okay, generally we have two cases to show that case. I gave the YouTube link here. It is not activated, I think. Second. Doctrine of ultravirus. I'll play this. Yeah, please look at this. What is doctrine? A set of rules or legal principles established through precedent on common law. Okay, doctrine means based on a law. Like here, what we Companies Act. Based on the Companies Act, for the purpose of companies has established certain rules and regulations. Right? So that is called doctrine. Ultravirus. What is an ultravirus? Means against the object laws of a company. So what is? Any contract entered by the company must be within the powers and object laid down in the memorandum of the company. If a company go beyond the objects laid in the memorandum of the company, then we call ultra virus. What is the purpose of ultravirus? To protect the investors and creditors of the company, to allow company to employ the money of investors as per stated. To enable investors to recognize the objects in which their money is to be employed, and helps creditors to protect funds of the company not used for unauthorized activity. So actually, that's what I said, objects clause. Under the objects clause, what we discussed, a company cannot not permitted to change its objections, because based on which investors came forward to invest in the company, and creditors or investors trusted and came forward to invest in the company. Creditors also came forward to lend money to the company. So, and feeling that they are protected, they're knowing the activities and the powers and the activities beyond limited to which company has permitted to work. If they want to change means it just means it is breaching the contract, breaching the trust of the investors and creditors. That's why they are not supposed to. So with this doctrine of ultraviolets, it enables the investors to recognize the objects in which their money is to be employed, and also has the creditors to protect funds of the company not used for unauthorized activity. There is a case study. You can give this case study. Yes, you are supposed to mention about this case study when you are writing about doctrine of ultraviolets. But this case study itself only, I am playing this video. Please go through. Carriage and iron. Beyond the object as defined in the object clause, the contract is void. The company had no capacity to ratify the contract. What are the exceptions? So I'll pay here. What is the decision? So this is the MOU, or Memorandum of Association. They said sell, borrow, rent, and supply carriage construction material. Directors entered into contract with the Richie for financing a construction of a railway line in Belgium. They gone against the company, and they go to he went to court against the company, railway carriage. As they worked against their MOA, the court said that the contract is void. So what ultraviolet says? Ultraviolets. What this doctrine of ultraviolet says? No act or purported act of the company, no conveyance shall be invalid by reason only. The exceptions to this ultraviolet is the holder secured by floating charge, trustees may be in proceedings against the company. So these are the exceptions. These people will not come under this ultraviolet. An officer or agent of the company under any authority can be taken against them by company or by any member of company. Okay, this is all in detail you are supposed to know. Officer includes the president of the former officer of the company. Actually, if you write the actual what is case, that is love. I hope you understood. So that's about so doctrine means a set of rules, regulations that laid by a common authority or a law, that is Companies Act. Ultra virus. Ultra means beyond virus powers. If a company works beyond the powers, then we say this. Once again, ultra virus. Okay, and company has no right to perform any of its functions beyond its powers. Now let us see about articles of association. Yes, articles next. So children, till now we discussed about Memorandum of Association and alteration of Memorandum of Association. Under the relating to the alteration of Memorandum of Association, Doctrine of Ultraviolets relating to change in the objects of the company. If a company goes beyond the powers, then what is Doctrine of Ultraviolets, and the case relating to the railway carriages and rich we discussed. Now, the next important document to be submitted at the time of incorporation of a company is Articles of Association. So, these Articles of Association is another important document to be submitted by the company at the time of incorporation of a company. Actually, this document is a second important document, and it tells, see, memorandum tells about the company's relationship with the outsider world. Okay, activities and the limits within which company acts. It tells about the outsider. Whereas Articles of Association says the rules and regulations for the internal management. Articles of Association sets its rules and regulations for the internal management of the company. Means for the internal people, how what are their rules and regulations, what are the duties and responsibilities relating to that, it tells articles. So see, a common, whatever to be informed to the public for every company is common. Like every company to the public has to inform about name, its registered office, its capital, its liability, members' liability, and its objectives. These are common, and what the details inside these changes from company to company. Are you getting? Memorandum of Association, what details gives about the name of the company, registered office of the company, objects of the company, capital of the company, liabilities of the company. So these are headings. Under each heading, company details from XYZ company. Whatever the number of companies, those details changes from company to company. Name, but these details, 5 details are common for every company to give in the memorandum, right? So we discussed these are the details to be given in the memorandum. Now coming to the Articles of Association. Articles of Association is a secondary important, and under this document, the company gives rules and regulations relating to the internal management of the company. For internal, what are the rules and regulations for internal management are required? Those are specified under the Articles of a company, Articles of Association, and these rules and regulations set for internal management of company differs from company to company. Under this, we are going to discuss regarding what topics they specify under this document, the contents. Okay. These are the contents of Articles of Association. So regarding these all documents, they are these are all details, information they discuss in detail. Again, relating to these headings, company to company, the information changes. Let us see what are the details. See, share capital and so name, cost, name, details. All these are common for every company. After that, the main contents they discuss upon in the Articles of Association. Contents of Articles of Association means in the Articles of Association regarding what topics a company will specify the rules and regulations. We are going to look into that. The rules and regulations changes from company, but what are the topics they specify In the articles we are showing here. Share capital, what is the share capital? What are the rights of the shareholders, and various how they differ from how their rights differ from one shareholder to other shareholders, they specify. Next, lien on shares. Lien on shares means do they transfer the, 1 second, I'll tell you this lien on shares, just a minute. Let me recall one. Calls on shares means company, how many shares? Calls on shares means in company accounts you will get is in detail. Say if share value is 10 rupees, company will not collect entire share value at a time from the shareholder. It collects in installments. First time at the time of application, second time on allotment of the shares. The remaining balance it collects in installments. Those installments generally in a company language we call as a calls. So how many calls, how many installments company wants to make on the shares will be discussed, and for each call how much gap to be there, and for each call how much amount of share to be collected will be discussed under the calls on shares. Next, transfer of shares. What are the generally share companies shareholders are free to transfer their shares, but certain shares has restrictions. So relating to the transfer of shares, they'll discuss under this. Transmission of shares from one firm to other firm. So company may change its preferential shares to equity shares, or debentures to debentures or no shares. So one firm to other firm, where if a company wants to make a shares, what are the rules and when a company can convert its preferential into equity? What are the rules and regulations to be followed? All those terms and conditions are discussed under transmission. Forfeiture of shares. Forfeiture is the term again in company accounts will get means cancellation of shares. Means company after issuing the shares to the shareholder, if the shareholders does not make the payment of a share value on calls of the company, in spite of giving a required notice, then company has a right to cancel his shares. That cancellation of shares is called as forfeiture of shares. So under this heading, company discuss about what are the rights and duties, when a company can forfeit the shares of the shareholder. Okay, and how many notices to be issued, what and what conditions it can issue, it can forfeit. All these details, terms and conditions will be discussed under the forfeiture of shares. Buyback of shares, like see, recently we heard about certain companies buying back. Wipro buy back their shares. Infosys buy back their shares. Tata buy back shares. Means what? They issued the shares to the shareholders, but after certain time, they may feel will buy our shares from our customers. Means company itself buy its own shares from the shareholders. So that is called buyback of shares. And when the company can do that, okay, it is not that whenever you feel. Again, everything has to be under the terms and rules and regulations. So when a company can go for buyback of its shares, what are the terms and conditions, rules and regulations to be followed will be discussed. The next one is conversion of shares into stock. When company can convert into stocks, that I discuss. Alternation of share capital. If a company wants to alter its share capital, again, relating to that terms and conditions also. Any other managerial matters, dividend, issue of dividends to the shareholders, amount of dividends to be issued, okay, when to issue, interim dividends, okay, all these they will discuss. Borrowing powers. What are the borrowing powers given to the company and the managing director, means board of directors? To what extent? What are the assets can be offered as security? All these are discussed under borrowing powers. Accounts and auditing, and relating to the maintenance of books of accounts, okay, and auditing. All these, you may get relating to accounts and auditing. What terms and conditions, madam? Yes. What are the books? Do they need to follow cost accounting system or not? They need to go for a management accounting system or not? And who can be the head? Who can take in charge? All these details and the responsibilities will be general meetings, directors meetings, additional relating to those all matters. They'll discuss under the content articles of association. Once the terms and conditions of each of these contents are discussed and provided in the articles of association, and this also will be signed by the subscribers and the witness, and included with the along with the other documents at the time of incorporation of a company and submitted to the registrar. And even these articles of association may be required for alteration. Okay. Alteration. Yes. Limitations. Actually, these limitations should come later. Okay. Alteration of articles of association. Even articles of association, though it is for internal management of the company, a company has to do very carefully. Okay. But whatever the care has taken, sometimes there may be a situation arises for their alteration, that is change in the contents of the articles of association. The company has to change, alter its articles of association. First of all, again, there it was any alteration relating to the company information involves various efforts and various rules and regulations and terms and conditions. Similarly, the articles of association. The alteration must not exceed the powers given by the memorandum. Okay, whatever the memorandum has mentioned, because all articles of association is next to memorandum only. Okay, though it is a second important document and internal management purpose, but it should not go beyond the terms and conditions mentioned in the memorandum of association. Alteration must not exceed the powers given by the memorandum and must not be for the purpose of any illegal activities. Okay, and it should be permitted in the articles. Alteration must be part of articles of association, must also be permitted in the articles at the time of first time when you prepared. Okay. And next reason, it should not be for the purpose of compelling any of the member or the subscriber to buy the shares or accept the more liability. Okay. And have a respect to effects. Alternation shall not prone increase liability of members more contracted. Limitations of alteration. Again, a company can exercise the power to alter its articles subject to the following limitations. First, the alteration of articles must not be inconsistent with any provisions of the Companies Act, means within the Companies Act. Articles cannot authorize a company to pay dividends out of its capital. Okay, and the following case. Articles cannot authorize a company to pay dividends out of its capital. That's about. Okay. And there is, to prove that, there is one more case given about it. Madhav Ramachandra Kamanath versus Canara Bank Corporation. Okay, and relating to this, I did not find any video. Actually, it is a case that is coming to the company passed a resolution that a member and the authorizing directors to register the transfer of shares without transfer deed. They can register the transfer of shares without any deed. That is what the resolution company passed. Okay, then they held a resolution and violated the provisions relating to the transfer of shares under the Companies Act. That so this Madhav Ramachandran has filed a suit against the company and won the case. Okay, that's the simple case relating to the limitation of alteration of articles of association. That's about today's class. The differences, coming to the differences, just a minute, let me request. Yes. So differences, if you see, Memorandum of Association as a main document, articles is secondary important document. Nature defines the relationship of company with the outside world. Articles defines the relationship of company for the internal management, rules and regulations for the internal. Status, supreme document, it is subordinate to the memorandum. Ultravirus, a company which is ultravirus, the memorandum is void and inoperative, means if beyond the powers if you go, a company cannot operate. Okay. And a company which is ultravirus of articles can be ratified by the shareholders. Alteration involves a huge expense and involves various legal formalities and special resolution plus central government permission. Alteration of articles, special resolution is enough. So these are the major differences of what you call alteration of differences between the Articles of Association and Memorandum of Association. If you have any doubts, you can please. Do you have any doubts, children? You can unmute yourself.
No, ma'am.
In next class, tomorrow's class, we come with the prospectus. And if time permits, after prospectus, we can get into the block 2 about management of companies, in which we learn about director and position of directors. Okay. In tomorrow's class, we discuss about prospectus, what is prospectus and what are the contents in the prospectus. After that, block 2, management of companies, under which we discuss about director and the position of directors. Thank you so much. Thank you for being here, and we'll meet tomorrow next class. If you have any doubts, you can. Shall we leave? This subject is business law subject, children. If you are joining in the middle, the link, looking at the link against your link, and in your timetable very clearly it was given, it's a subject code 12, paper code 12, and subject business law. Okay, I hope no one has doubts. So let us take care. Take care. Bye-bye.